Chapter 12. Margin and Credit. Section 48. Margin Requirements. 48.1. For the purpose of preventing the excessive use of credit for the purchase or carrying of securities, the Commission, in accordance with the credit and monetary policies that may be promulgated from time to time by the Monetary Board of the Banco Central ng Pilipinas, shall prescribe rules and regulations with respect to the amount of credit that may be extended on any security. For the extension of credit, such rules and regulations shall be based upon the following standard. An amount not greater than the whichever is the higher of a. 65%, 65%, of the current market price of the security, or b. 100%, 100%, of the lowest market price of the security during the preceding 36 calendar months, but not more than 75%, 75%, of the current market price. However, the Monetary Board may increase or decrease the above percentages, in order to achieve the objectives of the government with due regard for promotion of the economy and prevention of the use of excessive credit. Such rules and regulations may make appropriate provision with respect to the carrying of under-margined accounts for limited periods and under specified conditions, the withdrawal of funds or securities, the transfer of accounts from one lender to another, special or different margin requirements for delayed deliveries, short sales, arbitrage transactions, and securities to which letter b. of the second paragraph of this subsection does not apply, the methods to be used in calculating loans and margins and market prices, and similar administrative adjustments and details. 48.2. No member of an exchange or broker or dealer shall, directly or indirectly, extend or maintain credit is extended and maintain credit or arrange for the extension or maintenance of credit to or for any customer. A. On any security unless such credit is extended and maintained in accordance with the rules and regulations which the Commission shall prescribe under this section, including rules setting credit in relation to net capital of such member, broker, or dealer, and b. without collateral or any collateral other than securities, except I. to maintain a credit initially extended in conformity with rules and regulations of the Commission, and 2. in cases where the extension or maintenance of credit is not for the purpose of purchasing or carrying securities or of evading or circumventing the provisions of paragraph a. of this subsection. 48.3 Any person not subject to subsection 48.2 hereof shall extend or maintain credit or arrange for the extension or maintenance of credit for the purpose of purchasing or carrying any security, only in accordance with such rules and regulations as the Commission shall prescribe to prevent the excessive use of credit for the purchasing or carrying of or trading in securities in circumvention of the other provisions of this section. Such rules and regulations may impose upon all loans made for the purpose of purchasing or carrying securities limitations similar to those imposed upon members, brokers, or dealers by subsection 48.2 and the rules and regulations thereunder. This subsection and the rules and regulations thereunder shall not apply a. to a credit extension made by a person not in the ordinary course of business, b. to a loan to a dealer to aid in the financing of the distribution of securities to customers not through the medium of an exchange, or c. to such other credit extension as the Commission shall exempt from the operation of this subsection and the rules and regulations thereunder upon specified terms and conditions for stated period. Section 49. Restrictions on borrowings by members, brokers, and dealers. It shall be unlawful for any registered broker or dealer, or member of an exchange, directly or indirectly. 49.1. To permit in the ordinary course of business as a broker or dealer his aggregate indebtedness including customers' credit balances, to exceed such percentage of the net capital, exclusive of fixed assets and value of exchange membership, employed in the business, but not exceeding in any case 2000%, 2000%, as the Commission may be rules and regulations prescribe as necessary or appropriate in the public interest or for the protection of investors. 49.2. To pledge, mortgage, or otherwise encumber or arrange for the pledge, mortgage, or encumbrance of any security carried for the account of any customer under circumstances, a. That will permit the commingling of his securities, without his written consent, with the securities of any customer, b. That will permit such securities to be commingled with the securities of any person other than a bona fide customer, or, c. That will permit such securities to be pledged, mortgaged, or encumbered, or subjected to any lien or claim of the pledgee, for a sum in excess of the aggregate indebtedness of such customers in respect of such securities. However, the Commission, having due regard to the protection of investors, may, by rules and regulations, allow certain transactions that may otherwise be prohibited under this subsection. 49.3. To lend or arrange for the lending of any security carried for the account of any customer without the written consent of such customer or in contravention of such rules and regulations as the Commission shall prescribe. Section 50. Enforcement of margin requirement and restrictions on borrowing. To prevent indirect violations of the margin requirements under Section 48, the broker or dealer shall require the customer in non-margin transactions to pay the price of the security purchased for his account within such period as the Commission may prescribe, which shall in no case exceed the prescribed settlement date. Otherwise, the broker shall sell the security purchased starting on the next trading day but not beyond 10 trading days following the last day for the customer to pay such purchase price, unless such sale cannot be effected within said period for justifiable reasons. The sale shall be without prejudice to the right of the broker or dealer to recover any deficiency from the customer. To prevent indirect violation of the restrictions on borrowing under Section 49, the broker shall, unless otherwise directed by the customer, pay the net sales price of the securities sold for a customer within the same period as above prescribed by the Commission, provided that the customer shall be required to deliver the instruments evidencing the securities as a condition for such payment upon demand by the broker. Chapter 13. General Provisions. Section 51. Liabilities of controlling persons, aider and abettor and other secondary liability. 51.1. Every person who, by or through stock ownership, agency, or otherwise, or in connection with an agreement or understanding with one or more other persons, controls any person liable under this code or the rules or regulations of the Commission thereunder, shall also be liable jointly and severally with and to the same extent as such controlled persons to any person to whom such controlled person is liable, unless the controlling person proves that, despite the exercise of due diligence on his part, he has no knowledge of the existence of the facts by reason of which the liability of the controlled person is alleged to exist. 51.2. It shall be unlawful for any person, directly, or indirectly, to do any act or thing which it would be unlawful for such person to do under the provisions of this code or any rule or regulation thereunder. 51.2. It shall be unlawful for any director or officer of, or any owner of any securities issued by, any issuer required to file any document, report, or other information under this code or any rule or regulation of the Commission thereunder, without just cause, to hinder, delay or obstruct the making or filing of any such document, report, or information. 51.3. It shall be unlawful for any person to aid, abet, counsel, command, induce or procure any violation of this code, or any rule, regulation, or order of the Commission thereunder. 52.4. Every person who substantially assists the act or omission of any person primarily liable under Sections 57, 58, 59, and 60 of this code, with knowledge or in reckless disregard that such act or omission is wrongful, shall be jointly and severally liable as an aider and abettor for damages resulting from the conduct of the person primarily liable, provided, however, that an aider and abettor shall be liable only to the extent of his relative contribution in causing such damages in comparison to that of the person primarily liable, or the extent to which the aider and abettor was unjustly enriched thereby, whichever is greater. Section 52. Accounts and records, reports, examination of exchanges, members, and others. 52.1. Every registered exchange, broker, or dealer, transfer agent, clearing agency, securities association, and other self-regulatory organization, and every other person required to register under this code, shall make, keep and preserve for such periods, records, furnish such copies thereof, and make such reports, as the Commission by its rules and regulations may prescribe. Such accounts, correspondence, memoranda, papers, books, and other records shall be subject at any time to such reasonable periodic, special or other examinations by representatives of the Commission as the Commission may deem necessary or appropriate in the public interest of for the protection of investors. 52.2. Any brother, dealer, or other person extending credit, who is subject to the rules and regulations prescribed by the Commission pursuant to this code, shall make such reports to the Commission as may be necessary or appropriate to enable it to perform the functions conferred upon it by this code. 52.3. For purposes of this section, the term records refers to accounts, correspondence, memoranda, tapes, discs, papers, books and other documents or transcribed information of any type, whether written or electronic in character. Section 53. Investigations, injunctions, and prosecution of offenses. 53.1. The Commission may, in its discretion, make such investigations as it deems necessary to determine whether any person has violated or is about to violate any provision of this code, any rule, regulation, or order thereunder, or any rule of an exchange, registered securities association, clearing agency, other self-regulatory organization, and may require or permit any person to file with it a statement in writing, under oath, or otherwise, as the Commission shall determine, as to all facts and circumstances concerning the matter to be investigated. The Commission may publish information concerning any such violations, and to investigate any fact, condition, practice, or matter which it may deem necessary or proper to aid in the enforcement of the provisions of this code, in the prescribing of rules and regulations thereunder, or in securing information to serve as a basis for recommending further legislation concerning the matters to which this code relates, provided, however, that any person requested or subpoenaed to produce documents or testify in any investigation shall simultaneously be notified in writing of the purpose of such investigation, provided, further, that all criminal complaints for violations of this code, and the implementing rules and regulations enforced or administered by the Commission shall be referred to the Department of Justice for preliminary investigation and prosecution before the proper court, provided, furthermore, that in instances where the law allows independent civil or criminal proceedings of violations arising from the same act, the Commission shall take appropriate action to implement the same, provided, finally, that the investigation, prosecution, and trial of such cases shall be given priority. 53.2. For the purpose of any such investigation, or any other proceeding under this code, the Commission, or any officer designated by it is empowered to administer oaths and affirmations, subpoena witnesses, compel attendance, take evidence, require the production of any book, paper, correspondence, memorandum, or other record which the Commission deems relevant or material to the inquiry, and to perform such other acts necessary in the conduct of such investigation or proceedings. 53.3. Whenever it shall appear to the Commission that any person has engaged or is about to engage in any act or practice constituting a violation of any provision of this code, any rule, regulation, or order thereunder, or any rule of an exchange, registered securities association, clearing agency, or other self-regulatory organization, it may issue an order to such person to desist from committing such act or practice, provided, however, that the Commission shall not charge any person with violation of the rules of an exchange or other self-regulatory organization unless it appears to the Commission that such exchange or other self-regulatory organization is unable or unwilling to take action against such person. After finding that such person has engaged in any such act or practice and that there is a reasonable likelihood of continuing, further or future violations by such person, the Commission may issue ex parte cease and desist order for a maximum period of 10 days, enjoining the violation and compelling compliance with such provision. The Commission may transmit such evidence as may be available concerning any violation of any provision of this code, or any rule, regulation, or order thereunder, to the Department of Justice, which may institute the appropriate criminal proceedings under this code. 53.4. Any person who, within his power but without cause, fails or refuses to comply with any lawful order, decision, or subpoena issued by the Commission under subsection 53.2 or subsection 53.3 or section 64 of this code, shall after due notice and hearing, be guilty of contempt of the Commission. Such person shall be fined in such reasonable amount as the Commission may determine, or when such failure or refusal is a clear and open defiance of the Commission's order, decision, or subpoena, shall be detained under an arrest order issued by the Commission, until such order, decision, or subpoena is complied with. Section 54. Administrative Sanctions. 54.1. If, after due notice and hearing, the Commission finds that, a. there is a violation of this code, its rule, or its orders, b. any registered broker or dealer, associated person thereof has failed reasonably to supervise, with a view to preventing violations, another person subject to supervision who commits any such violation, c. any registrant or other person has, in a registration statement or in other reports, applications, accounts, records, or documents required by law or rules to be filed with the Commission, made any untrue statement of a material fact, or omitted to state any material fact required to be stated thereof are necessary to make the statements therein not misleading, or, in the case of an underwriter, has failed to conduct an inquiry with reasonable diligence to ensure that a registration statement is accurate and complete in all material respects, or, d. any person has refused to permit any lawful examinations into its affairs, it shall, in its discretion, and subject only to the limitations hereinafter prescribed, impose any or all of the following sanctions as may be appropriate in light of the facts and circumstances. I. Suspension, or revocation of any registration for the offering of securities. 2. A fine of no less than 10,000 pesos, P10,000.00, nor more than 1,000,000 pesos, P1,000,000.00, plus not more than 2,000 pesos, P2,000,000.00, for each day of continuing violation. 3. In the case of a violation of sections 19.2, 20, 24, 26, and 27, disqualification from being an officer, member of the Board of Directors, or person performing similar functions, of an issuer required to file reports under Section 17 of this Code or any other act, rule, or regulation administered by the Commission. 4. In the case of a violation of Section 34, a fine of no more than 3 times the profit gained or loss avoided as result of the purchase, sale, or communication proscribed by such section, and v. other penalties within the power of the Commission to impose. 54.2. The imposition of the foregoing administrative sanctions shall be without prejudice to the filing of criminal charges against the individuals responsible for the violation. 54.3. The Commission shall have the power to issue writs of execution to enforce the provisions of the section and to enforce payment of the fees and other dues collectible under this code. Section 55. Settlement offers. 55.1. At any time, during an investigation or proceeding under this code, parties being investigated and/or charged may propose in writing an offer of settlement with the Commission. 55.2. Upon receipt of such offer of settlement, the Commission may consider the offer based on timing, the nature of the investigation or proceeding, and the public interest. 55.3. The Commission may only agree to a settlement offer based on its findings that such settlement is in the public interest. Any agreement to settle shall have no legal effect until publicly disclosed. Such decision may be made without a determination of guilt on the part of the person making the offer. 55.4. The Commission shall adopt rules and procedures governing the filing, review, withdrawal, form of rejection and acceptance of such offers. Section 56. Civil liabilities on account of false registration statement. 56.1. Any person acquiring a security, the registration statement of which or any part thereof contains on its effectivity an untrue statement of a material fact or omits to state a material fact required to be stated therein or necessary to make such statements not misleading, and who suffers damage, may sue and recover damages from the following enumerated persons, unless it is proved that at the time of such acquisition he knew of such untrue statement or omission. A. The issuer and every person who signed the registration statement. B. Every person who was a director of, or any other person performing similar functions, or a partner in, the issuer at the time of the filing of the registration statement or any part, supplement, or amendment thereof with respect to which his liability is asserted. C. Every person who is named in the registration statement as being or about to become a director of, or a person performing similar functions, or a partner in, the issuer and whose written consent thereto is filed with the registration statement. D. Every auditor or auditing firm named as having certified any financial statements used in connection with the registration statement or prospectus. E. Every person who, with his written consent, which shall be filed with the registration statement, has been named as having prepared or certified any part of the registration statement, or as having prepared or certified any report or valuation which is used in connection with the registration statement, with respect to the statement, report, or valuation, which purports to have been prepared or certified by him. F. Every selling shareholder who contributed to and certified as to the accuracy of a portion of the registration statement, with respect to that portion of the registration statement which purports to have been contributed by him. G. Every underwriter with respect to such security. 56.2. If the person who acquired the security did so after the issuer has made generally available to its security holders an income statement covering a period of at least 12 months beginning from the effective date of the registration statement, then the right of recovery under this subsection shall be conditioned on proof that such person acquired the security relying upon such untrue statement in the registration statement or relying upon the registration statement and not knowing of such income statement, but such reliance may be established without proof of the reading of the registration statement by such person. Section 57. Civil liabilities arising in connection with prospectus, communications, and reports. 57.1. Any person who a. offers to sell or sells a security in violation of Chapter 3, or b. offers to sell or sells a security, whether or not exempted by the provisions of this code, by the use of any means or instruments of transportation or communication, by means of a prospectus or other written or oral communication, which includes an untrue statement of a material fact or omits to state a material fact necessary in order to make the statements, in the light of the circumstances under which they were made, not misleading, the purchaser not knowing of such untruth or omission. And who shall fail in the burden of proof that he did not know, and in the exercise of reasonable care could not have known, of such untruth or omission, shall be liable to the person purchasing such security from him, who may sue to recover the consideration paid for such security with interest thereon, less the amount of any income received thereon, upon the tender of such security, or for damages if he no longer owns the security. 57.2. Any person who shall make or cause to be made any statement in any report, or document filed pursuant to this code or any rule or regulation thereunder, which statement as at the time and in the light of the circumstances under which it was made false or misleading with respect to any material fact, shall be liable to any person who, not knowing that such statement was false or misleading, and relying upon such statement shall have purchased or sold a security at a price which was affected by such statement, for damages caused by such reliance, unless the person sued shall prove that he acted in good faith and had no knowledge that such statement was false or misleading. Section 58. Civil liability of fraud in connection with securities transactions. Any person who engages in any act or transaction in violation of sections 19.2, 20, or 26, or any rule or regulation of the Commission thereunder, shall be liable to any other person who purchases or sells any security, grants or refuses to grant any proxy, consent or authorization, or accepts or declines an invitation for tender of a security, as the case may be, for the damages sustained by such other person as a result of such act or transaction. Section 59. Civil liability for manipulation of security prices. Any person who willfully participates in any act or transaction in violation of Section 24 shall be liable to any person who shall purchase or sell any security at a price which was affected by such act or transaction, and the person so injured may sue to recover the damages sustained as a result of such act or transaction. Section 60. Civil liability with respect to commodity futures contracts and pre-need plans. 60.1. Any person who engages in any act or transactions in willful violation of any rule or regulation promulgated by the Commission under Section 11 or 16, which the Commission denominates at the time of issuance as intended to prohibit fraud in the offer and sale of pre-need plans or to prohibit fraud, manipulation, fictitious transactions, undue speculation, or other unfair or abusive practices with respect to commodity future contracts, shall be liable to any other person sustaining damages as a result of such act or transaction. 60.2. As to each such rule or regulation so denominated, the Commission by rule shall prescribe the elements of proof required for recovery and any limitations on the amount of damages that may be imposed. Section 61. Civil liability on account of insider trading. 61.1. Any insider who violates subsection 27.1 and any person in the case of a tender offer who violates subsection 27.4, a, I, or any rule or regulation thereunder, by purchasing or selling a security while in possession of material information not generally available to the public, shall be liable in a suit brought by any investor who, contemporaneously with the purchase or sale of securities that is the subject of the violation, purchased or sold securities of the same class unless such insider, or such person in the case of a tender offer, proves that such investor knew the information or would have purchased or sold at the same price regardless of disclosure of the information to him. 61.2. An insider who violates subsection 27.3 or any person in the case of a tender offer who violates subsection 27.4, a, or any rule or regulation thereunder, by communicating material non-public information, shall be jointly and severally liable under subsection 61.1 with, and to the same extent as, the insider, or person in the case of a tender offer, to whom the communication was directed and who is liable under subsection 61.1 by reason of his purchase or sale of a security. Section 62. Limitation of actions. 62.1. No action shall be maintained to enforce any liability created under Section 56 or 57 of this Code unless brought within 2 years after the discovery of the untrue statement or the omission, or, if the action is to enforce a liability created under subsection 57.1, a, unless, brought within 2 years after the violation upon which it is based. In no event shall such action be brought to enforce a liability created under Section 56 or subsection 57.1, a, more than 5 years after the security was bona fide offered to the public, or under subsection 57.1, b 0 more than 5 years after the sale. 62.2. No action shall be maintained to enforce any liability created under any other provision of this Code unless brought within 20 years after the discovery of the facts constituting the cause of action and within 5 years after such cause of action accrued. Section 63. Amount of damages to be awarded. 63.1. All suits to recover damages pursuant to Sections 56, 57, 58, 59, 60, and 61 shall be brought before the Regional Trial Court, which shall have exclusive jurisdiction to hear and decide such suits. The Court is hereby authorized to award damages in an amount not exceeding triple the amount of the transaction plus actual damages. Exemplary damages may also be awarded in cases of bad faith. fraud, malevolence, or wantonness in the violation of this code or the rules and regulations promulgated thereunder. The court is also authorized to award attorney's fees not exceeding 30% of the award. 63.2. The persons specified in sections 56, 57, 58, 59, 60, and 61 hereof shall be jointly and severally liable for the payment of damages. However, any person who becomes liable for the payment of such damages may recover contribution from any other person who, if sued separately, would have been liable to make the same payment, unless the former was guilty of fraudulent representation and the latter was not. 63.3. Notwithstanding any provision of law to the contrary, all persons, including the issuer, held liable under the provisions of sections 56, 57, 58, 59, 60, and 61 shall contribute equally to the total liability adjudged herein. In no case shall the principal stockholders, directors, and other officers of the issuer or persons occupying similar positions therein, recover their contribution to the liability from the issuer. However, the right of the issuer to recover from the guilty parties the amount it has contributed under this section shall not be prejudiced. Section 64. Cease and desist order. 64.1. The Commission, after proper investigation or verification, motu proprio, or upon verified complaint by any aggrieved party, may issue a cease and desist order without the necessity of a prior hearing if in its judgment the act or practice, unless restrained, will operate as a fraud on investors or is otherwise likely to cause grave or irreparable injury or prejudice to the investing public. 64.2. Until the Commission issue a cease and desist order, the fact that an investigation has been initiated or that a complaint has been filed, including the contents of the complaint, shall be confidential. Upon issuance of a cease and desist order, the Commission shall make public such order and a copy thereof shall be immediately furnished to each person subject to the order. 64.3. Any person against whom a cease and desist order was issued may, within 5 days from receipt of the order, file a formal request for a lifting thereof. Said request shall be set for hearing by the Commission not later than 15 days from its filing, and the resolution thereof shall be made not later than 10 days from the termination of the hearing. If the Commission fails to resolve the request within the time herein prescribed, the cease and desist order shall automatically be lifted. Section 65. Substituted service upon the Commission. Service of summons or other process shall be made upon the Commission in actions or legal proceedings against an issuer or any person liable under this code who is not domiciled in the Philippines. Upon receipt by the Commission of such summons, the Commission shall within 10 days thereafter, transmit by registered mail a copy of such summons and the complaint or other legal process to such issuer or person at his last known address or principal office. The sending thereof by the Commission, the expenses for which shall be advanced by the party at whose instance it is made, shall complete such service. Section 66. Revelation of information filed with the Commission. 66.1. All information filed with the Commission in compliance with the requirements of this code shall be made available to any member of the general public, upon request, in the premises and during regular office hours of the Commission, except as set forth in this section. 66.2. Nothing in this code shall be construed to require, or to authorize the Commission to require, the revealing of trade secrets or processes in any application, report, or document filed with the Commission. 66.3. Any person filing any such application, report, or document may make written objection to the public disclosure of information contained therein, stating the grounds for such objection, and the Commission may hear objections as it deems necessary. The Commission may, in such cases, make available to the public the information contained in any such application, report, or document only when a disclosure of such information is required in the public interest or for the protection of investors, and copies of information so made available may be furnished to any person having a legitimate interest therein at such reasonable charge and under such reasonable limitations as the Commission may prescribe. 66.4. It shall be unlawful for any member, officer, or employee of the Commission to disclose to any person other than a member, officer or employee of the Commission or to use for personal benefit, any information contained in any application, report, or document filed with the Commission which is not made available to the public pursuant to subsection 66.3. 66.5. Notwithstanding anything in subsection 66.4 to the contrary, on request from a foreign enforcement authority of any country whose laws grant reciprocal assistance as herein provided, the Commission may provide assistance in accordance with this subsection, including the disclosure of any information filed with or transmitted to the Commission. If the requesting authority states that it is conducting an investigation which it deems necessary to determine whether any person has violated, is violating, or is about to violate any laws relating to securities or commodities matters that the requesting authority administers or enforces, such assistance may be provided without regard to whether the facts stated in the request would also constitute a violation of law of the Philippines. Section 67. Effect of action of Commission and unlawful representations with respect thereto. 67.1. No action or failure to act by the Commission in the administration of this code shall be construed to mean that the Commission has in any way passed upon the merits of or given approval to any security or any transactions therein, nor shall such action or failure to act with regard to any statement or report filed with or examined by the Commission pursuant to this code or the rules and regulations thereunder to be deemed a finding by the Commission that such statements or report is true and accurate on its face or that it is not false or misleading. It shall be unlawful to make, or cause to be made, to any prospective purchaser or seller or a security any representation that any such action or failure to act by the Commission is to be so construed or has such effect. 67.2. Nothing contained in subsection 67.1 shall, however, be construed as an exemption from liability of an employee or officer of the Commission for any nonfeasance, misfeasance, or malfeasance in the discharge of his official duties. Section 68. Special accounting rules. The Commission shall have the authority to make, amend, and rescind such accounting rules and regulations as may be necessary to carry out the provisions of this code, including rules and regulations as may be necessary to carry out the provisions of this code, including rules and regulations governing registration statements and prospectuses for various classes of securities and issuers, and defining accounting, technical, and trade terms used in this code. Among other things, the Commission may prescribe the form or forms in which required information shall be set forth, the items or details to be shown in the balance sheet and income statement, and the methods to be followed in the preparation of accounts, appraisal or valuation of assets and liabilities, determination of depreciation and depletion, differentiation of recurring and non-recurring income, differentiation of investment and operating income, and in the preparation, where the Commission deems it necessary or desirable, of consolidated balance sheets or income accounts of any person directly or indirectly controlling or controlled by the issuer, or any person under direct or indirect common control with the issuer. Section 69. Effect on existing law. The rights and remedies provided by this code shall be in addition to any and all order rights and remedies that may now exist. However, except as provided in Section 56 and 63 hereof, no person permitted to maintain a suit for damages under the provisions of this code shall recover, through satisfaction of judgment in one or more actions, a total amount in excess of his actual damages on account of the act complained of, provided that exemplary damages may be awarded in cases of bad faith, fraud, malevolence, or wantonness in the violation of this code or the rules and regulations promulgated thereunder. Section 70. Judicial review of Commission orders. Any person aggrieved by an order of the Commission may appeal the order to the Court of Appeals by petition for review in accordance with the pertinent provisions of the Rules of Court. Section 71. Validity of contracts. 71.1. Any condition, stipulation, provision binding any person to waive compliance with any provision of this code or of any rule or regulation thereunder, or of any rule of an exchange required thereby, as well as the waiver itself, shall be void. 71.2. Every contract made in violation of any provision of this code or of any rule or regulation thereunder, and every contract, including any contract for listing a security or an exchange heretofore or hereafter made, the performance of which involves the violation of, or the continuance of any relationship or practice in violation of, any provision of this code, or any rule or regulation thereunder, shall be void. A. As regards the rights of any person who, in violation of any such provision, rule, or regulation, shall have made or engaged in the performance of any such contract, and b. As regards the rights of any person who, not being a party to such contract, shall have acquired any right thereunder with actual knowledge of the facts by reason of which the making or performance of such contract was in violation of any such provision, rule, or regulation. 71.3. Nothing in this code shall be construed a. To affect the validity of any loan or extension of credit made or of any lien created prior or subsequent to the effectivity of this code, unless at the time of the making of such loan or extension of credit or the creating of such lien, the person making such loan or extension of credit or acquiring such lien shall have actual knowledge of the facts by reason of which the making of such loan or extension of credit or the acquisition of such lien is a violation of the provisions of this code or any rules or regulations thereunder, or b. To afford a defense to the collection of any debt, obligation, or the enforcement of any lien by any person who shall have acquired such debt, obligation or lien in good faith for value and without actual knowledge of the violation of any provision of this code or any rule or regulation thereunder affecting the legality of such debt, obligation, or lien. Section 72. Rules and Regulations, Effectivity. 72.1. This code shall be self-executory. To effect the provisions and purposes of this code, the Commission may issue, amend, and rescind such rules and regulations and orders necessary or appropriate, including rules and regulations defining accounting, technical, and trade terms used in this code, and prescribing the form or forms in which information required in registration statements, applications, and reports to the Commission shall be set forth. For purposes of its rules or regulations, the Commission may classify persons, securities, and other matters within its jurisdiction, prescribe different requirements for different classes of persons, securities, or matters, and by rule or order, conditionally or unconditionally exempt any person, security, or transaction, or class or classes of persons, securities, or transactions, from any or all provisions of this code. Failure on the part of the Commission to issue rules and regulations shall not in any manner affect the self-executory nature of this code. 72.2. The Commission shall promulgate rules and regulations providing for reporting, disclosure, and the prevention of fraudulent, deceptive or manipulative practices in connection with the purchase by an issuer, by tender offer or otherwise, of an equity security of a class issued by it that satisfies the requirements of subsection 17.2. Such rules and regulations may require such issuer to provide holders of equity securities of such dates with such information relating to the reasons for such purchase, the source of funds, the number of shares to be purchased, the price to be paid for such securities, the method of purchase and such additional information as the Commission deems necessary or appropriate in the public interest or for the protection of investors, or which the Commission deems to be material to a determination by holders whether such security should be sold. 72.3. For the purpose of subsection 72.2, a purchase by or for the issuer or any person controlling, controlled by, or under common control with the issuer, or a purchase subject to the control of the issuer or any such person, shall be deemed to be a purchase by the issuer. The Commission shall have the power to make rules and regulations implementing this subsection, including exemptive rules and regulations covering situations in which the Commission deems it unnecessary or inappropriate that a purchase of the type described in this subsection shall be deemed to be a purchase by the issuer for the purpose of some or all of the provisions of subsection 72.2. 72.4. The rules and regulations promulgated by the Commission shall be published in 20 newspapers or general circulation in the Philippines, and unless otherwise prescribed by the Commission, the same shall be effective 15 days after the date of the last publication. Section 73. Penalties. Any person who violates any of the provisions of this code, or the rules and regulations promulgated by the Commission under authority thereof, or any person who, in a registration statement filed under this code, makes any untrue statement of a material fact or omits to state any material fact required to be stated therein or necessary to make the statements therein not misleading, shall, upon conviction, suffer a fine of not less than 50,000 pesos, p. 50,000.00, nor more than 5,000,000 pesos, p. 5,000,000.00, or imprisonment of not less than 7 years nor more than 21 years, or both in the discretion of the court. If the offender is a corporation, partnership, or association or other juridical entity, the penalty may in the discretion of the court be imposed upon such juridical entity and upon the officer or officers of the corporation, partnership, association, or entity responsible for the violation, and if such officer is an alien, he shall in addition to the penalties prescribed, be deported without further proceedings after service of sentence. Section 74. Transitory Provisions. The Commission, as organized under existing laws, shall continue to exist and exercise its powers, functions, and duties under such laws and this code, provided, that until otherwise mandated by a subsequent law, the Commission shall continue to regulate and supervise commodity futures contracts as provided in Section 11 and pre-need plans and the pre-need industry as provided in Section 16 of this code. All further requirements herein shall be complied with upon approval of this code, provided, however, that compliance may be deferred for such reasonable time as the Commission may determine but not to exceed 1 year from approval of this code, provided, further, that securities which are being offered at the time of effectivity of this code pursuant to an effective registration and permit, may continue to be offered and sold in accordance with the provisions of the Revised Securities Act. In effect immediately prior to approval of this code. All unexpended funds for the calendar year, properties, equipment, and records of the Securities and Exchange Commission are hereby retained by the Commission as reorganized under this code, and the amount of 200 million pesos, p. 200,000,000.00, or such amount necessary to carry out the reorganization provided in this code is hereby appropriated. All employees of the Commission who voluntarily retire or are separated from the service with the Commission and whose retirement or separation has been approved by the Commission, shall be paid retirement or separation benefits and other entitlement granted under existing laws. Section 75. Partial use of income. To carry out the purposes of this code, the Commission is hereby authorized, in addition to its annual budget, to retain and utilize an amount equal to 100 million pesos, p. 100,000,000.00, from its income. The use of such additional amount shall be subject to the auditing requirements, standards, and procedures under existing laws. Section 76. Repealing Clause. The Revised Securities Act, Batas Pambansa BLG 178, as amended, are hereby repealed. All other laws, orders, rules, and regulations, or parts thereof, inconsistent with any provision of this code are hereby repealed or modified accordingly. Section 77. Separability Clause. If any portion or provision of this code is declared unconstitutional or invalid, the other portions or provisions hereof, which are not affected thereby shall continue in full force and effect. Section 78. Effectivity. This code shall take effect 15 days after its publication in the Official Gazette or in two newspapers of general circulation. Approved, July 19, 2000.